Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
All right, good morning and welcome to the June docket for the Court of Criminal Appeals sitting here in Nashville. Today our panel, we're pretty well rounded. We represent all three grand divisions. So to my right is Judge John Campbell from Memphis, and to my left is Judge Kyle Hickson from Knoxville, and I'm Judge Jill Ayers from Clarksville, Tennessee. So welcome everyone. And I think looking around, most everybody has been here before, so you know you've got 20 minutes per side. If you want to reserve any rebuttal time, let us know, and the timer will keep up with your time. Any preliminary matters?
No, Your Honor.
All right, if you'll call the first case then, please.
State of Tennessee versus Michael Chad Owens.
I would have been in the proper seat had I known we were first. I thought we were second. I apologize.
That's okay.
Good morning. My name is Minji Ball. I'm from the DeKalb County Bar, and thank you for having me here today. I am here on behalf of the appellant, Michael Chad Owens. Michael Chad Owens.
Before you get, do you want to reserve any rebuttal time?
Yes, Your Honor. Thank you. I'd like to reserve 2 minutes.
Okay, thank you. Clerk just needs to know to keep up with that.
Yes, Your Honor. Thank you. Mr. Owens was convicted by a jury on April the 6th, 2023 on 4 separate counts. The first count was sale and delivery of a Schedule 1 heroin of 0.10 grams. The second count was delivery of a Schedule 1 heroin of the same one as count 1. Count 3 is the sale of Schedule 2 methamphetamine under 0.5 grams. Count 4 was delivery of Schedule 2 methamphetamine under 0.5 grams. He was also, in this jury trial, assessed with fines, which, as part of my brief, we believe to be extremely excessive. He was assessed with count 1, sale of heroin, $40,000 fine. Count 2, delivery of heroin, $15,000 fine. Count 3, sale of methamphetamine, $20,000 fine. Count 4, delivery of methamphetamine, $15,000 fine. I believe it's relevant in this case for the court to know that the heroin was 0.10 grams or less, according to the TBI report, and the methamphetamine was under the 0.5. It was right at 0.2 grams of methamphetamine. On June 20th, 2023, following a sentencing hearing, Mr. Owens was sentenced as a persistent offender at the maximum range, being 30 years concurrent with count 1 and 2, and 15 years concurrent for count 3 and 4, with a combined sentence of 45 years at 45%. We also bring before this court that that sentence is excessive, and I'll discuss that a little more later. Your Honor, I filed a motion for a new trial, which was denied. I filed an amended motion for a new trial that was denied. We filed pre-trial motions that were all denied for the exclusion of evidence. I timely filed this appeal with the court. We filed an original brief and an amended brief just to get the court up to date. In summary, during trial, there were 2 videos shown. The first video was for count 1 and count 2, which showed Mr. Owens in a vehicle outside of a very small park where the CI, who is also the last name of Owens, but they are of no relation, walked up to the vehicle. Mr. Owens threw out on the ground what appeared to be a pack of cigarettes, and the CI was upset about that he threw something on the ground, and then she threw him money. That was the end of their encounter. There was no discussions. There was no text messages presented. There was no sworn statement from my client. He didn't make any confessions. During the heroin buy, there was no discussions about it being heroin, about the cost of the heroin. There was just that one short video. The CI was not presented at the trial. The CI had prior passed away at no fault of my clients, and she was not presented at trial. She was not presented at any post-trial hearings, which is another one of the big issues that we hope to raise today. I have quite a few issues. I hope to get
You
through
do.
them all.
I'm wondering how you're going to get to them and which ones you're going to focus on.
Yes,
Go ahead.
Yes, Your Honor. And so just letting the court know what the issues are. And on the second one was the methamphetamine, where the CI went to Mr. Owens' residence, went into the residence, and there was a brief discussion in the video about methamphetamine and the price. That was completely different than the video of the heroin. The state's witnesses...
I mean, you're acting like that was the only evidence, but in fact, the law enforcement who set up the controlled buys testified about all that and explained what it all was. Is that not correct?
Yes, Your Honor. I was going to go with the state's witnesses, did a live video feed, and they testified that they had received heroin from the CI from the first buy and received methamphetamine from the CI from the second buy, that they followed her with a live feed the entire time. In the heroin case, which I believe is one of the biggest issues that we're here today, Your Honor, when the CI walks up to the vehicle and that exchange occurs, the CI then goes and sits down on a park bench, and the video goes out for just a second. We're not stating that that was enough to alter or to do anything. But once the video goes out, when the video comes back, Miss Owens is observed pulling something from her bra area, pulling something out of her bra area and lighting it with a lighter. When both Detective Williams, Chief Deputy Williams, and Detective Barrett were questioned about that, they did not know that Miss Owens had a cigarette pack on her. They did not know that she had a lighter on her. And the reason that that's the most important, I believe, is that the cigarette pack is what was purported to be the vessel transporting the heroin. And so if the law enforcement during their prior search and their after search did not notice that Miss Owens had a cigarette pack in her possession, that creates a serious issue with the chain of custody. And that's what we're asking this court to find. Yes,
Let
sir.
me ask you a question about that. I mean, what I understand your argument is that that she had this on her and they missed it.
Yes, sir.
Is that correct? Doesn't that go to your argument to the jury about whether the officers actually see and whether or not, as opposed to the admissibility or the introduction of this evidence before the jury? You're saying this is some kind of a issue that is suppressible, that therefore the packet that was found on the ground of the officers, that somehow that makes it inadmissible?
Yes, Your Honor. We're claiming that the chain of custody, although we are very familiar with case laws and findings that you do not have to prove every link to the chain of custody, as long as the links that you prove are adequate, we're asking this court to find that there was a breach in the very first link of the chain of custody. And that goes into the next issue, which was the inability to cross-examine Miss Owens.
Before we move,
Yes, sir. Yes, sir.
That's all.
hot mic. Before we move on to the cross-examination issue, was there an objection at trial as to the chain of custody?
Yes, Your Honor. There was a pre-motion objection, there was an objection during trial, and then there was an objection in my motion to amend.
Okay. So I believe the state's arguing in their brief that there was not an objection at trial, that the trial court had reserved its ruling to hear the proof at trial, and that there was no objection. So you would disagree with that assertion?
I would agree that the court denied my motion without a hearing, and also denied my motion for a new trial without a hearing. I just received the orders of denial in the mail, and so I believe that in effect was his denial of my motions through order.
No, what I think what Judge Hickson is talking about is at the time these were introduced,
Yes, sir.
we know there was some pretrial hearing, because I don't think the transcript of whatever suppression matter was ever prepared, so we don't know what was argued at that point. But when the matter was introduced, when these items were introduced, there was not a contemporaneous objection.
That's correct, Your Honor. The objection came after, and
Came
one-
after,
in the motion for a new trial.
so that with no contemporaneous objection at trial, isn't this issue waived?
No, Your Honor, I don't believe it is. If you go further, in a jury out hearing, I raised the issue of Ms. Owens tampering with evidence, prior charges, and how we didn't have a right to impeach her, and the court found that she wasn't a witness. I didn't have the right to impeach her, and I believe that in itself preserved that issue for this court.
Well, cross-examination and impeachment, that's a different animal than
Yes, sir.
a chain of custody once a piece of evidence is admitted. So if there was no contemporaneous objection at the time that this evidence was admitted, is that issue not waived?
I don't believe it's waived, Your Honor, because the appellate court has given us the ability to fix any errors that were made in trial in our motion for a new trial, outlining those specific issues. Actually,
Which appellate court has done that?
Your Honor, I don't have, it's in my brief, but my brief is pretty extensive.
Because I believe this
apologize.
appellate court and the
Sir.
Tennessee Supreme Court have specifically said if you want to object on an evidentiary basis, you have to make a contemporaneous objection stating that basis at trial in order to preserve it for appeal.
Yes, sir.
So under that controlling law, is this issue not waived?
Your Honor, I do not believe the issue was waived because it was properly brought before the court at a later date. And if I may just briefly, one of the other issues that I raised is a motion for a mistrial, which I did raise in court, in chambers several times. I was very challenged during the trial with my clients being seriously under the influence of something to where he was sweating profusely.
Let me stop
Yes,
you for a
sir.
second, because
Yes, sir.
I went through the record trying to find any reference to this motion for mistrial,
Yes, sir.
and there is nothing in there.
Yes, sir.
So, you know, we're stuck with a situation where if there was an argument made and the court made findings or rulings, we don't have the benefit of that in this record because there's nothing there. So without it being the record, how is this not waived?
Your Honor, I believe that this is not waived, as most of the issues with my clients being seriously under the influence was in jury out, off-the-record hearings, but there is one, I believe, which thankfully is in there.
Are you
that-
saying all the, gosh, these are really hot. Are you saying all of the jury out hearings were not transcribed or even taken down as they happened?
Yes, yes, Your Honor, there were a few, not all. There were a few that were done in chambers and a few that where the court was addressing my client and his behaviors. There was one I know specifically that was preserved on the record where the court had my client get up and swear that he was not under the influence of any drugs because his behaviors were erratic. That is part of the court.
But none of that's in the record.
That one would be in the record.
But my understanding of what the court did in that situation was he made an inquiry of your client, ruled that he was not intoxicated, and just said he was trying to distract and interfere with the process. So
Yes.
he made a determination. He apparently believed your client when your client said he wasn't under the influence and felt that he was just trying to be, obstructive as far as the trial is concerned. All the other things you're talking about are not in the record at all. So it's, kind of hard to, it's like they don't exist, really.
It is a challenge, Your Honor, and I understand that. But we are asking the court to find that due to my client being under the influence, which was also reported in the pre-sentencing report, which the judge addressed. The pre-sentencing report, my client admitted to that probation officer that not only was he under the influence when he arrived to trial, but during breaks he continued to use drugs. The issue with that is my client was incarcerated for almost 2 years awaiting trial, and somehow 2 weeks before trial he was let out of jail. I didn't find out about it until later. Even the district attorney's office didn't find out about it until later, and it was during that period of time that we believe he relapsed. But his behavior at trial was very challenging, and I understand this court's position. And on the confrontation clause, if I may briefly, the issue is that my client has a right to confront and cross-examine witnesses, and I did get in through Chief Deputy Williams' testimony that Ms. Owens had prior issues with tampering with evidence and things of that nature, and I believe that my client had a right to defense to attach or to attack the credibility of the first link in the chain of custody, which was, I received these drugs off of this person, and I turned these drugs unaltered over to the law enforcement. We
But
believe
she didn't testify.
that's correct, Your Honor. She did not testify, and we.
So,
Mhm.
what testimonial statements were admitted that would, so you can impeach a hearsay declarant, right?
Yes, sir.
And under the constitutional rubric, it would have to be a testimonial statement in order for the right to cross-examination to attach. So what testimonial statements were admitted that you think should have given you the right to cross-examine Ms. Owens?
Your Honor, very specifically, it was a jury out hearing, but it did make the record. And when I asked Chief Deputy Williams about Ms. Owens's prior issues with evidence, and he said, I think she ate a pill or something. She had a history of it, but the problem was.
Not what you wanted to impeach her with.
Yes, sir.
What declarations came out of her mouth that were testimonial in the confrontation sense? Because I read your brief carefully,
Yes, sir.
and I was waiting to see, okay, what did Ms. Owens say? What factual declaration did she say on these recordings that would qualify as being testimonial? And I couldn't find anything.
There were none on the videos. The only thing that we believe would have been testimonial in nature would be where the law enforcement obtained those drugs should have been presented in a testimony, other than they testified they received them from her. That was an act that we weren't really able.
And you testified them, or you cross-examined
Yes,
them
sir.
because
Yes,
they
sir.
testified.
Yes, sir.
Ms. Owens didn't testify.
That's correct.
So did she make any testimonial declaration that was captured on these recordings that was admitted at trial?
No, sir. She made no statements on the recordings.
Then how do you have a confrontation issue?
Your Honor, I believe the confrontation issue was our inability to confront the first link in the chain of custody, being Ms. Owens, to determine her credibility and her ability to properly secure evidence and to turn it over. We believe that my client had a right to confront and cross-examine her and to bring his own witnesses forward, and that would have been Ms. Owens.
Thank you.
Yes, sir, thank you. The next issue, Your Honor, which was the high school photo that was admitted into evidence, we believe that was a big
What was
issue.
what was prejudicial about that?
Your Honor, the photo, which is in evidence, shows Miss Owens in her senior class high school photo. There was no reason for it to be admitted. It didn't help the case in any way.
Now, you didn't object to it.
I did, Your Honor. I filed a pretrial motion
But
to
when it was
object.
introduced, there
Yes,
was
sir.
no contemporaneous objection.
That's correct, Your Honor. Prior to it being introduced, we had an in-chambers. There were several in-chambers, and I know next time that I will make sure that does not happen.
Because
But-
there's no transcript.
Yes, sir. There was an in-chambers meeting where the court said that, not to waste time, we bring in same motions that he's already denied, and he previously denied that motion. And my alternative was I could have submitted a motion of her incarcerated, her mugshot, which I'm not really sure would have been very helpful to my client either. But I believe that showing a senior high school photo of a person that the jury knows is deceased from a drug overdose, while my client is on.
Did they know that particular fact?
Yes,
that
Your
she had
Honor.
died of a drug overdose?
Yes, Your Honor. It was in the newspaper. It was.
Well, yeah, but
whoa.
that's different from
Yes.
whether it was evidence in front of this jury.
Yes, Your Honor.
Was it evidence in front of this jury at trial?
Was there testimony?
I don't believe there was. I don't recall if there was testimony. But the only purpose to show.
Well, before
Yes, sir.
you say that the jury knows
Yes, sir.
that this lady passed away from a drug overdose, you should be able to point to the record and say where that was admitted at trial before you make a statement like that to this court, don't you think?
Yes, Your Honor. I'll retract that statement.
Okay.
What was known in trial was that she was deceased and was not available. Her reason for passing was not in the trial, but that was what her obituary was. We have one radio station. We have one local
Again,
newspaper.
that's not relevant if it wasn't admitted at trial.
And what was the prejudice of showing this particular picture?
To inflame the jury as to it being a high school person, a high school senior that he's selling drugs to. We believe the only purpose was to inflame the jury. I believe
Thank you.
that
You'll still
concludes
have
my
your 2
time.
minutes. Yeah.
Yes, thank you.
Thank you, ma'am.
General Ball, we thought you were going to make an introduction.
Excuse me, I'd be happy to. I thought we had missed our opportunity
That's all good.
when there was no preliminary matters called.
No problem.
Good morning. May it please the court. Ben Ball on behalf of the state here to introduce one of our newest attorneys having his very first argument. This is Ryan Dugan. He comes to us fresh out of law school from Washington University in St. Louis, and we are thrilled to have him.
Great. Welcome, General Dugan.
Oh, thank you so much, Your Honor.
Welcome.
All right. Good morning, Your Honors. May it please the court. Ryan Dugan on behalf of the state. This court should affirm the judgment of the trial court. This case comes out of an operation by the DeKalb County Sheriff's Department where they used a confidential informant to purchase heroin and then methamphetamine from the defendant. And as has been discussed, the confidential informant passed away prior to trial. But the defendant was convicted of the sale and delivery of methamphetamine and the sale and delivery of heroin and sentenced to an effective 45-year sentence. I'm going to confine my argument to the issues that we have discussed already and rely on my brief for the other issues, but if this court has questions on any of those issues,
I may ask you about sentencing when we get to the tail end of it, 'cause I may ask Ms. Ball about that as
Okay.
well.
So the first issue was the chain of custody issue, and as has been discussed, the trial court in its ruling denying the motion to suppress only ruled on the admissibility of the videos of the controlled purchases, and it reserved all other evidentiary issues for trial, and there was no contemporaneous objection made, so this would be here on plain error. And the defendant cannot show the violation of a clear and unequivocal rule of law in this ruling. The audio and video recordings showed the entirety of the time in which the confidential informant was in possession of the narcotics. Chief Deputy Williams and Detective Barrett testified that they met the confidential informant in a local fire station, and Chief Deputy Williams testified that he thoroughly searched the defendant's person and found no contraband prior to either controlled buy. And then the video shows the confidential informant get into a van with the police officers, drive to the location of the controlled buys. It shows her entire walk to the defendant. It shows the purchase of the controlled substances. And in the first video, while one of the cameras does go dark when she sits down, the other camera is still going the entire time. So there is a video that was seen by the jury of that 1 or 2 second gap. And then the video shows the confidential informant walk back to the officers and give Chief Deputy Williams the cigarette packet for the heroin and a piece of paper that was folded over for the methamphetamine. So from that, a jury could conclude that the heroin and methamphetamine were those objects and that there was an unbroken chain of custody.
Where did the cigarette come from?
The cigarette, the lighter or the cigarette itself? Or both?
I guess both.
Well, it is not clear. The record doesn't really show where those came from, but I know Chief Deputy Williams testified that he found no contraband on the confidential informant's person, that cigarettes aren't contraband, so that might have been on her person, and just that was not relevant to Chief Deputy Williams when he was doing the search. But
Were these male officers
Yes,
conducting
they
the
were.
search? And I hear your friend on the other side is saying that the cigarette that Ms. Owens appeared to have pulled it from her bra. Was there testimony that indicated how extensive this search was?
Detective Barrett testified that it was an extensive search. The record will make this clear. I don't remember exactly, but no, Detective Barrett does testify about searching her bra area or her having to empty it or something. I know there is testimony about the search and her bra area. I just can't recall the exact specifics of that at this moment.
But you think that is in the record?
It is in the record, Your Honor. During, I believe it's Detective Barrett's testimony at trial. And then the defendant cannot show that a substantial right was adversely affected because this was an evidentiary ruling, and these do not often rise to the level of affecting a constitutional right or the defendant's fundamental criminal process rights, so that the defendant has not established either of those plain error requirements and cannot show that he is entitled to relief on that claim. Moving to the defendant's issue about the mistrial or a continuance, as your honors pointed out, the record does not show a motion for a mistrial being made at trial. And from the jury out hearing that we do have in the record, the trial court called the jury out hearing sua sponte and then addressed the defendant and told him, you know, look like you're falling asleep. You told me under oath that you were not under the influence of any substances. I'm finding you credible when you told me that. So he just gave the defendant a couple moments to collect himself, get ready for trial to resume again. And after that, the record does not show any other issues of that regard. So there was not a manifest necessity to declare a mistrial in this instance. And then in the defendant's brief, there is a discussion about after the lunch break, the defendant appeared to be sweating, I believe, but once again, there was no motion for a mistrial made. So the defendant would have waived that issue by not making a contemporaneous motion for a mistrial at that moment. Unless the court has any additional questions on that issue.
I do have a question, and it's involving sentencing, and I'm
Yes.
about the fines.
Yes, Your Honor.
Okay, the jury, and the fines are within the range that the legislature has set out. Does the judge have a responsibility then to see whether the defendant is capable of paying these enormous fines?
I believe this court has held that is a requirement. However, the fines were not raised until the motion for new trial. So at the sentencing hearing, there's no discussion, at least in the transcript, of fines. And the motion for new trial hearing isn't included. There's no transcript of that in the record. And the trial court does say that it came after a hearing on the motion for new trial. So I would just argue that there is not a sufficient record for this court to determine if the trial court made those factual findings or not.
Well, did the trial court make those findings at the sentencing hearing?
At the sentencing hearing, no, there was no discussion of fines at that hearing.
And am I correct that there was no actual hearing on the motion for new trial, that it was denied by order?
In the trial court's order denying the motion for new trial, it did say this came after a hearing, which according to that would make it appear that there was a hearing on the motion, but the record is not clear as to whether, there's no transcript, so we don't know from that basis whether.
And we don't have a minute entry or anything like that?
I think there's no minute entry on we had a hearing.
Right.
There's just an order denying the motion for new trial, and that's all that we really have on the motion for new trial.
Why would that issue be relevant if there was a motion for new trial
Yes.
hearing? Why would the issue of fines be relevant there?
I know defendants have often raised sentencing issues in motions for new trial.
Pretty common, as a matter of fact.
Yeah, and this is a sentencing issue. It is a part of the overall sentence. And so this was the first opportunity in which the trial court was, that became an issue, I guess is one way to say it. The defendant did not raise the fine issue. The state didn't discuss fines at the sentencing hearing. So this was the first time the trial court had squarely before it, an objection from the defendant that these fines are excessive. So at that hearing, it would then have the opportunity to look into the issue, make factual findings, issue a ruling, and determine whether the fines were excessive or not. But there is no record of that hearing, assuming it took place, which the record purports that it seems to have happened.
Okay.
And unless there's any questions on that, I believe the next issue was the confrontation issue. The defendant cannot show that there was testimonial hearsay that was admitted. This is once again on plain error because that one was not on plain error, I apologize. So for this, their audio quality in the controlled by video is not the best. The only conversations I was able to very clearly hear from was, I believe there was one about the price of heroin during the heroin controlled by, and then there was discussions of ancillary miscellaneous things that I think there was one about the defendant or someone thought that the confidential informant looked like that she had lost weight recently. So that was not one of these issues, but the defendant cannot show that there was testimonial hearsay in the video. The purpose of the video was not admitted to prove the truth of what the price of heroin was. It was admitted to show that an interaction occurred and that the confidential informant left that with heroin that she received from the defendant.
Wasn't that kind of what my impression, what the court was ruling on the issue was that whatever she said was not hearsay because it wasn't offered for the truth of the matter, sir?
Yes.
Basically, with the court.
Yes, in the order in allowing the admission, the trial court made a couple factual findings. I think one of them was that this was not introduced to prove the truth of any matters asserted in the video. So this is not hearsay, and the confidential informant did not testify at trial, so there's no hearsay declarant at trial issues with that. So, and then once again, the intent behind the investigation was the narcotics. It was not to get statements from the defendant that could be used at trial. And if the court doesn't have any questions about that issue.
Can I ask you a more, or are you moving on to something else?
You can ask.
Well, thank you. I was gonna circle back to sentencing. I
Yes,
know
Your
there's a
Honor.
lot of talk about fines.
Yes.
This gentleman has a 45-year sentence. Did you read the appellant's brief to make a general argument as to the length of the sentence?
There is a section in the appellant's principal brief which does argue that the sentence is excessive. So in that sense, there was an argument that I guess the length of it and the non-fine aspects were excessive too. Is that what Your Honor was?
Yes.
Yes. Do you want me to respond to that argument? Is that what you're?
Sure.
Oh,
yeah.
okay. So
I mean, we do have 45 years here
Yes.
for a relatively small amount of drugs.
Yes, Your Honor. So the defendant was sentenced as a range 3 offender. The trial court found several enhancement factors, most notably that the defendant had a criminal history in excess of the amount required to establish his range, and that the defendant had previously failed to abide by the conditions of his release into the community. I believe the trial court found, I think there was evidence presented that the defendant had 7 felony convictions, 5 misdemeanor convictions, and 9 revocations of supervised release, which the record clearly supports the imposition of those 2 enhancement factors. And as this court has held, any one enhancement factor is sufficient to justify an enhanced sentence. And then 2 consecutive sentencing, I believe the trial court based that off of the first factor, which is that the defendant's criminal history was extensive, and that the defendant that he relied on criminal activity for a substantial portion of his livelihood. And once again, I believe the record clearly supports those consecutive sentencing factors. So I think the record supports the trial court's discretionary determination that based on the record before it, a 45-year sentence was justified based on the facts of the case.
Thank you, General.
No problem. And then the last issue that was discussed was the introduction of the photograph of the confidential informant. This one, once again, is here on plain error because similarly, the motion to suppress did not rule on this issue and there was no contemporaneous objection made. There was no prejudice from the introduction of this photograph. The probative value of it was mostly to show the jury who the confidential informant was, because you never see her face on the videos. To show that Chief W. Williams interacted with her, was familiar with her. He could discuss what happened in the investigation, and it was to aid the jury in knowing the context of the case.
Was it a recent photograph? How old was she when she passed away?
I do not know, Your Honor. I don't know if her age is. I don't remember that being in the record clearly, but if it is, I defer to the record. I believe there was also, never mind, sorry. But it was sufficient for Chief W. Williams to see her and identify who she was. That is the one thing I do remember about that. And then, once again, the defendant cannot show really any prejudice that abounded from this. So in that sense, a clear and unequivocal rule of law was not violated.
Well, wasn't it a high school picture? Wasn't she wearing like a cheerleading outfit or something like that?
I do not recall, Your Honor. I believe there was a discussion about the recentness in the record, and I think the state did not think that it was a high school senior photograph. I do not recall the exact specifics of.
Yeah, I think
that
Mr. Owens claims in his brief that the picture was 20 years old. I don't know if that's borne out by the record, but if that's the case, could that not inflame a jury that we're showing a picture of basically a high school student who this gentleman is preying upon and selling drugs to?
If that is the case, Your Honor, I don't know if that would lead to prejudice, because in the videos, while you cannot see her face, it is clear from the video that she is not in high school, just off the way she carries herself. You can hear her voice, the way she talks. I don't think that I think there is evidence that she was not in high school in the record that the jury would be able to consider as well, but I do not know. I do not remember the exact specifics of the photograph and how old she was in it. But in any
I
event,
mean, if there's that kind of evidence about, what she may or may not have looked like, or something to support the fact that she's not a high school student, why was it relevant to introduce a high school photograph?
if it was a high school photograph, I think it still goes to the fact that Chief Debbie Williams was able to identify her based on a picture of her. I do not think that changes necessarily the relevance of at least that aspect of it. But I don't think it affects it terribly much. But then also the defendant cannot show that a substantial right was adversely affected because, once again, this was an evidentiary ruling. It did not affect the defendant's fundamental criminal process rights. And review is not necessary to do substantial justice because any error if this ruling was an error, it was clearly a harmless error. And unless the court has any more questions, we ask that you affirm. Thank you.
Thank you, General.
Thank you. Ms. Ball, you still have your 2 minutes.
Yes, Your Honor, as always, I wish I had more time in life and in all things. Your Honor, briefly, just touching on the photo, it was a senior high school photo, the one you take in your senior year that puts you in the fake top that has the background. She was 17 and a half during the photo. When she passed away, she was in her mid-40s. At the time of this buy, she was in her mid-40s and lived a hard life of drugs. And we reiterate the inflammatory nature of the jury seeing someone as a high school student that Mr. Owens, who is an African-American, middle-aged man, he has distinguished tattoos. They required him to show some tattoos in court for his identity purposes. We believe that it was very inflammatory. But as far as the question that I was not able to answer earlier, in my response to the appellee brief, the primary purpose of filing a motion for a new trial in Tennessee is to preserve issues for appeal, providing the trial court with an opportunity to consider or reconsider alleged errors. It clearly states consider or reconsider. This process ensures that the trial court has the chance to correct any errors before the cause proceeds to appellate review. Tennessee Rule of Appellate Procedure 3E explicitly requires that issues such as errors in the admission or the exclusion of evidence, jury instructions, or misconduct during the trial must be raised in a motion for a new trial to avoid being waived on appeal. This is State v. Harbison and Rule 3 appeal as of right. And those are the issues. As far as the fines, Your Honor, the only evidence as to my client's ability to earn an income was presented through the pre-sentencing report, and he at one time had worked at Pizza Hut for a month or two, and at one time had worked at a factory for a couple of months. That was the extensive of his history. His grandmother testified that he lived with her, he helped her out, and that she financially supported him, and so the fines are excessive. This was my client's first time from range 1 to range 3, and he went to the max. That's my argument as to excessive sentence, and I rely on my brief for the remainder.
Right. Thank you both.
Thank
We
you.
appreciate your briefs and your arguments.